Welcome back. Thanks for staying with us. Cosatu is calling for the scrapping of provisions in the Basic Education Laws Amendment Bill that criminalise disruption of schools. It says the bill infringes on the rights of education workers on strike. So for more on Cosatu's stance on the bill, I'm joined by its parliamentary coordinator, Mathew Parks. Mr. Parks, very good evening to you. Thank you for your time. So Parliament's Basic Education Committee has been hearing oral submissions on the very contentious Basic Education Laws Amendment Bill, with presentations pushing back hard against certain provisions in the proposed laws. Now, you've been making submissions. One of your inputs is that Parliament scrap the provisions that criminalise the disruption of schools. How would you define the disruption of schools?
Sure. So look, overall the bill has many progressive provisions, and many of them are long overdue, and they can help make a positive impact on education, which will benefit society. We were concerned about a few areas. The one provision that you mentioned, in essence, it just says simply, it is a very broad definition, that it's a criminal offence to disrupt schooling. So we think the intention was to deal with, community protests, which often get violent, which do disrupt schooling. We understand the logic around that, and that is fine, because it is an offence to damage property, to intimidate people, physically threaten people, and so forth. But when you take a very broad definition which says it's a criminal offence to disrupt schooling, that means the definition can include strikes. It means it can include when teachers or other educational workers might have a lunchtime picket or a protest and so forth. So that's taken the definition too far, because people have a constitutional right to picket, to protest, even to strike. If the Department of Education is concerned about interruption to schooling or threats to people or to property, those are already covered for in the law. You cannot, damage any property. You cannot threaten anybody. And even on the issue of strikes and pickets and protests, under the Labour Relations Act, there are picketing rules put in place between employers and employees. And if they can't agree to some parameters on that, as an education department, as teachers, for example, then the CCMA has a standard template which can guide pickets and protests and strikes. Where can you protest? How many meters from the school entrance and so forth? But we think that the department in this instance has gone a bit too far to say that any disruption of schooling would be a criminal offence, because in effect you would then be saying teachers could never go on strike without being in risk of being put in jail. So we don't think this clause will pass constitutional muster. We think that Parliament should revise it, make it more clear about it's speaking specifically to criminal activities, vandalism, etc., physical threats, but it should be made clear it's not interfering with the constitutional right to picket or to protest or to strike even.
So you're ultimately saying people who disrupted schools should be penalized, but teachers should be considered differently, because then they would be, disrupting schools on a legal strike.
Yeah. So look, we live in a constitutional democracy. Everybody's got the right to protest. So anybody's got the right, including teachers. And there are rules already within place within the Labour Relations Act, or within other legislation, which says how can you manage those protests. Whether there's a strike, then the LRA will come into effect. You can guide, including picketing rules, how many meters you can be from the school to do your picket and so forth. Equally, for example, the Regulation of Gatherings Act governs community protests and so forth. So those are fine. But the wording in the bill is very clumsy when it simply says any disruption of schooling will be a criminal offence. So that would mean that if teachers who are meant to be teaching in class have got a legal strike certificate, are thus entitled and protected to go on strike, this bill would undermine those legal provisions and say, well, in effect, because you're not in the classroom, you have disrupted schooling, and therefore you're guilty of a criminal offence. So it actually contradicts the existing laws in place on the Labour Relations Act, the Regulation of Gatherings Act, the Constitution. So it needs to be fixed. It needs to be made very clear that this is only for protests which are violent, which physically threaten people, which damage property. Then it's fine. Then it makes sense, and that's a correct position to take.
Yeah.
But you can't just simply say that, the catering staff who are not providing meals at lunchtime, you have disrupted schooling because you didn't provide meals, and therefore you can go to prison. That would be undermining the constitutional right of those workers.
There's also been a lot of debate around, the provisions allowing schools to sell alcohol on their premises as a fundraising activity. What's your view on that?
Sure. So look, I think with any law, any policy in society, you have to balance, and often you have to balance contradictions. We think there is space in South Africa for a reasonable, responsible relationship with alcohol, the responsible consumption. But right now we have a real problem with alcohol abuse, including in particular amongst young people who often are engaged in binge drinking with serious damage to their health. We have huge levels of road accidents, often fatalities, domestic violence, gender-based violence, a lot of violence over weekends, and there's a huge linkage in that regard to alcohol. Young people are also still learning. They're still influenced by what others do. And we know with young people at school, there's a real tendency towards binge drinking. So we think there's a space for alcohol in society, but we don't think that space is for schools. Teachers themselves have said, look, they have enough on their hands to manage schools, to keep learners safe. They don't need to also be now policing a social function where alcohol is served at schools. We understand the logic of saying that often the schools rent out their facilities for parties, activities, often need to sell alcohol to fundraise for the schools. But we think for the time being, given our real problem with alcohol, especially among young people, for the time being we need to prohibit the sale of alcohol at school until we manage to control the abuse of alcohol in society. And we can see during 2020 and COVID-19, when there were some restrictions on alcohol abuse, not a ban, which is not sustainable, but some restrictions, it actually helped to decrease the amount of violence linked to alcohol, amount of road accidents, amount of people going to hospital emergency rooms, and that is a positive thing. So we think we need to begin to shift society towards a more responsible relationship with alcohol, especially amongst young people. So I think for us, we're a bit concerned about the provision of the bill, which will allow the sale of alcohol at schools. We think that's not a right approach to take for now.
Yeah. You've also spoken to the bill's provisions extending compulsory, schooling from grade 1 to grade R, saying that perhaps it should go a step further and be extended from grade 9 to grade 12. As you make that suggestion, I mean, it really speaks to the high dropouts that we've seen when, the matrics, the learners eventually get to matric, that the numbers have substantially dropped by the time they even reach matric.
Yeah. So one of the reasons why we think there are many good parts in the bill is, for example, the requirement and the formalization that grade R will now be part of the formal school curriculum. That's a positive thing because research has shown that kids who have been to creche or educare, have been to grade R, have a much better foundation when they go to grade 1. This helps put them in a better place to ensure a successful school career. So it's positive. Of course, it means the Department of Education has to put in place the necessary infrastructure, classrooms, teachers, resources to accommodate these children. But it's a good step forward. I think we hope that Parliament will be a bit bold and to say in the same spirit that we need to extend the compulsory school years, which currently end at age 15 or grade 9, up until grade 12 or age 19. We don't think we can afford an economy of a 44% unemployment rate or a youth unemployment rate of 60%, of an economy which really struggles to find skilled workers to fill many critical jobs. That we should be sending young people into that economy with very little education and skills, with very minimal qualifications. We're not doing them a favor. In fact, they're going to struggle to find decent work to sustain themselves, to raise their own families later on, to take care of their parents. Or we're not doing society a benefit because we're sending in an army of unskilled young people into an economy which needs skills. So we think you should either be required to complete school, go to grade 12, at least the age of 18. If not, then you should be required to be in a TVET college, getting some sort of skills training. But we should not be sending young people, kids basically, into the economy. We're not doing them a favor. We're not doing South Africa a favor. We should be investing as much as possible in young people's education, the skills to benefit them and their families and to benefit society at large. So we would hope Parliament would take this initiative and fill this critical gap.
Yeah, very well. Thank you so much. Thanks for weighing in on this discussion there, speaking to Cosatu's Mathew Parks.